Yes, my lord.
Appearances.
With the kind permission of your lordship, I most humbly, sir, announce my appearance for the defendant. My name is Sojitoki. I'm grateful, sir.
Did you serve hearing notice on the claimant?
Yes, my lord.
And you have the proof?
Yes, my lord.
Very well. No, court registrar.
Yes, my lord.
The notice that was served on the claimant was on the 14th. Was for the 14th.
My lord, this matter was adjourned in an open court.
Yes, it was adjourned for 14th, and I asked that you should move it because of the barrier we have. You should move it to today.
Yes, that proof of service of that one is not in the file, my lord.
Where is it? Do you have it?
Yes, my lord.
And it was received?
Yes, my lord.
Okay.
Yes, my lord.
Here is the judgment of the court.
The court places.
It is the claimant case that he was employed verbally by the respondent on the 29th of April 2010 and was confirmed by a letter dated 3rd July 2013 and has worked in several capacities till his dismissal on the 11th of October 2017. He averred that throughout his engagement with the defendant, he never misconducted himself or committed any criminal offense that warrants his dismissal. He stated that his dismissal letter contained a promise or undertaking by the defendant to pay all his outstanding entitlements, but it failed to do so despite a letter of demand written to them. He averred further that his monthly salary at the time of his dismissal was 28,233 naira per month, and going by the defendant's operational guideline and practice, is entitled to the said amount for 7 years that is served with the defendant. He continued that he was dismissed without prior notice or warning on any allegation, neither was he given any opportunity to defend himself. It is against this backdrop that he took out a general form of complaint in this court against the defendant on 15th of January 2019, wherein he prayed the court for the following reliefs. A declaration that the termination of claimant's employment be the letter of dismissal dated 11th of October 2017 was in breach of the rules of natural justice or constitutional right to fair hearing, and that the said decision and letter are null and void. B, a mandatory order for reinstatement of the claimant to employment and that all his salaries paid till date. C, an order of court quashing the dismissal of the claimant from the service of the respondent as same constitutes stigma and a violation of his contract of employment with the respondent. D, an order of court directing the respondent to pay the claimant the sum of 5 million naira only as damages for unlawful termination of employment. E, an order of court directing the respondent to pay the claimant the sum of 5 million naira only for attaching an insignia of dismissal as same amount to stigmatization. And F, cost of filing this suit. In the alternative, claimant is asking for a declaration that the termination of his employment, be the letter of dismissal dated 11th of October 2017, was in breach of the rules of natural justice or constitutional right to fair hearing, and that the said decision and letter are null and void. B, an order directing the respondent to immediately pay the claimant the sum of 193,000 naira, only representing his benefit during the period of his engagement by the respondent. C, an order of court directing the respondent to pay the claimant the sum of 5 million naira as damages for unlawful termination of employment. D, an order of court directing the respondent to pay the sum of 10 million naira, being special and general damages, to be paid to the claimant for wrongful dismissal. E, special damages made up of the following: A, salary due to the plaintiff from 11th of October 2017 to date. B, psychological trauma, 5 million naira. C, general damages, 5 million naira. And F, cost of filing this suit. Responding to the claimant claim, the defendant filed a statement of defense on 23rd of April 2019, wherein it averred that the claimant was not employed on the 29th of April 2010 as the claim, but on the 3rd of July 2013, and that he was a skilled staff and never worked in several capacities. It also averred that the claimant was a habitual rule breaker, heady, disobedient, unruly, and a truant, and has received several warnings, queries, and suspensions before he was finally dismissed, and was equally given a fair hearing, was allowed to defend himself before he was dismissed. It averred further that claimant physically assaulted another staff on the 10th of August 2017, which led to his query and subsequent dismissal. It continued that claimant is not entitled to the sum claim as he was dismissed from work. It further averred that after the claimant's dismissal in 2017, he pleaded that his dismissal be converted to termination, upon which he was invited, but he failed to honor the invitation, but sent a letter through his lawyer stating that he did not intend to continue working with the defendant. On the 14th of November 2019, claimant opened his case by testifying for himself as CW. He adopted his witness statement on oath of 15th of January 2019 and his additional statement of 16th of May 2019 as his oral evidence. He tendered documents admitted and marked as with C to C2. It was subsequently cross-examined by Sojitoki Esquire, counsel to the defendant. Afterwards, the claimant closed his case. Consequently, the defendant opened its case. On the 4th February 2020, called one Adebayo Iyakamu, production manager of the defendant, who testified as DW. He equally tendered documents admitted and marked as with AE and AE1. It was also cross-examined by counsel for the claimant. Thereafter, the defendant closed its case and case adjourned for filing of final written addresses of parties. In accordance with the rules of this court, parties filed their respective final addresses. The defense filed first and framed two issues. I've reduced the pertinent part of those issues and the argument for in this judgment. Counsel for the claimant also filed his final written address on the 20th December, and I've reduced that into the body of this judgment. I will now go straight to the decision of the court. After an in-depth consideration of the originating process, the statement of facts, along with other accompanying processes, the statement of defense with its accompanying processes, the final written addresses of parties, I am of the firm view that the sole issue that will best determine this suit is whether or not the claimant has proven his case on the balance of probabilities to be entitled to the relief sought. First, it is expedient to state that claimant in this case sought declaratory reliefs, which he must lead credible evidence in support of in order to succeed. This is because the claimant in declaratory action must rely on the strength of his own case and not on the weakness of the defendant's case. See the case of Anazongu and Onumbogu and other citation captured, the case of Ali, Ucha and another versus Elechi and other citation provided, the case of Mwokidu and Okanu citation captured, and Tata Muhammad citation equally provided. I must also say that claimant in this case sought alternative reliefs, and the position of the law as regards alternative reliefs is clear in that the law allows a claimant who seeks alternative reliefs to plead conflicting facts in line with the alternative relief sought. In the case of Adigi J. and Nwagu and other citation captured, Ugumiju JCA, now GSC, emphatically puts its doors, I quote, in civil litigation and indeed in election matters, a party can make two seemingly contradictory pleadings leading to two different heads of claim. That is why a petitioner can claim that the election be annulled for reason of substantial non-compliance, and in the same breath claim that he won the election by a majority of lawful votes. The petitioner may plead the same set of facts to grant alternative reliefs. Those pleadings are not ipso facto held to be self-contradictory. The court can only grant one relief, as the party must decide which relief is best supported by the evidence on record, unquote. See also the case of Abia State Independent Electoral Commission and Kano citation captured, GKFI Nigeria Limited and ITO citation provided, Newbury Organization Limited and Eromosele citation provided, Metal Construction WA Limited versus Abordering citation also provided. Assert claimant in this case is allowed to plead conflicting facts in relation to the alternative relief sought. It is the contention of claimant that his dismissal from employment was in breach of the rule of natural justice, that is fair hearing, as he was not allowed to defend himself in respect of the allegations against him for his dismissal, and as such, same is null and void. He had averred via paragraph 7 and 12 of the statement of facts that he was dismissed from employment without committing any criminal offense or engaging in any act of misconduct, and that prior to his dismissal, he was never served a pre-terminal notice. The defendant, in response via the statement of defense, particularly paragraph 5, averred that claimant was a habitual rule breaker and a truant who had received several warnings, queries, suspensions before he was finally dismissed, and that claimant was given fair hearing and allowed to defend himself before he was eventually dismissed. Claimant in response stated, be it paragraph 6 to 12 of his reply, that he was not an habitual rule breaker and truant, and that the queries given to him were satisfactorily answered by him, and also that he was not given a query as regards his inefficiency, thus denying him opportunity to defend himself on that allegation. He equally contended that his suspension had nothing to do with any misconduct, but was due to the issue of the insecurity in Abuja because of the Yanya bomb blast. He equally denied assaulting any of his colleagues, but it was only a mild altercation between him and that colleague. Claimant in this case, as seen in his letter of dismissal in Exhibit C1, was dismissed for truancy and continuous below average job performance. I must say that in cases of this nature, where an employee complains to the court of his dismissal on grounds of misconduct, what the court is expected to look out for first is whether the dismissal was in accordance with the terms of employment, and secondly, whether the principles of natural justice or fair hearing, which imposes a duty upon the employer to act fairly before dismissal of an employee, has been observed. See the case of Momo and CBN citation provided, AfriBank and Ochisonya citation provided, Yusuf and Union Bank citation provided. I peruse the condition of service which both parties agreed governed their employment relationship, that is Exhibit AE1, and I find that it provides for dismissal of an employee for misconduct. At its page 10 does, and I quote, dismissal. An employee may be dismissed for criminal offense or conviction in a court of law. 2, fraud or forgery. 3, continued absence from duty without permission. 4, continuous below average job performance. 6, serious misconduct as determined by the officer in charge of personnel administration or group head or GM or MD, unquote. The above provision of Exhibit AE1 is clear and requires no special aid to understand. There's no doubt that both parties are bound by the above provision of a condition of service as contained in Exhibit AE1. See the case of CBN and Archibald citation provided, the notorious case of Kato and CBN citation equally provided. From the said provisions, an employee may be dismissed for below average performance and some other misconduct, including quote and unquote serious misconduct as determined by the officer in charge of personnel administration, group head, GM, or MD. Claimant as reason supra was dismissed for truancy and continuous below average job performance. Howbeit, the law is firmly established that when an employer decides to dismiss an employee on ground of gross misconduct, the employer is duty-bound to afford the affected employee fair hearing. It would appear to be trite that a hearing need not attain the standard or form obtainable in a court of law before it can be said to be fair. Where a matter is not before a court of law, or what is generally required in order to accord fair hearing to a person is that there be an opportunity for an employee to be aware of the allegations against him and an opportunity to offer explanation in defense of same, which basically comes in form of queries, and depending on the provision of a contract, it may include setting up a panel of inquiry or geared towards affording the employee the right of hearing. The defendant had pleaded facts relevant to the queries and answers to queries by claimant and thus relied on Exhibit C3, which are the series of queries and answers to queries by claimant, which was tendered by the defendant through claimant during his cross-examination. The said letters of documents that made up Exhibit C3 being relevant to the facts pleaded by the defendant and having become evidence before the court, they can be relied on by any party to the proceedings to support its case. Besides, it is the law that evidence elicited through cross-examination can be relied upon by the party cross-examining. If the evidence elicited during cross-examination relates to a fact and issue, has the same probative value, and is as valid and authentic as evidence elicited during examination in chief. Please, if you are online, mute your phone, please. The court is delivering judgment. Please mute your phone. I don't want to hear any noise, please. See the case of Shimo and others versus Abul, citation captured, Omishori and Aregbeshola, citation provided, Piles and State, citation captured, Adeosho and Governor of Ekiti State, citation provided, Akomolafe and Guardian Press Limited, citation also captured. Thus, the fact that the defendant did not tender the said queries through its own witness DW will not in any way affect the case of the defendant, since the document has been tendered by it through its adversary. It helps to lend credence to the evidence of DW in his statement on oath that claimant was queried severally and also suspended, just as opponent is entitled to lead evidence on his adversary pleadings, so also a party can rely on document tendered through his opponent. More so, the law is tried that all documents tendered before a court at the trial of a case is part and parcel of the evidence to be considered in the determination of issues before the court. Such documents, usually referred to as exhibit, are subject to scrutiny and are to be tested for credibility and weight by the trial court. In the case of Chief Edem Ekon and Chief A.E. Otop and other citation provided. I perused the said series of queries and found that while some were issued as far back as 2014, which in my view may be too remotely relevant. Excuse me, please. Mute your phone. Mute your phone. If you are joining this online, mute yourself. Abuja, mute your phone. Infinix Hot 12, mute it. M.A. Shehu, mute your phone. Mute your audio. Infinix Hot 12, I'm waiting for you to mute your phone, please. Infinix Hot 12, mute your phone. Mute your phone, please. I perused the said series of queries and found that while some were issued as far back as 2014, which in my view may be too remotely relevant to claimant's dismissal, and I will explain the reason for this in the later part of this decision. Please mute your phone. If you're online, mute your phone. I don't want to hear any noise, please. The other query dated 11th August 2017 was issued just 2 months before claimant's dismissal for physically assaulting his colleague, to which claimant responded to. Claimant in this case has stated supra in his reply to statement of defense, denied physically assaulting his colleague, but that it was a mere altercation. I must say that from the content of the claimant's answer to query, claimant himself admitted that it was a physical assault between two fellow, contrary to his denial in his reply to statement of defense. Although physical assault for which claimant was queried just before his dismissal is not specifically listed as part of what an employee could be dismissed for, and the provision of Exhibit A1, which is the contract binding both parties, captured earlier in this judgment. I must, however, say that according to Exhibit A1, an employee could be dismissed for any act termed serious misconduct by the officer in charge of personnel administration or group head or GM or MD. Besides, I do not know of any employment where an alleged physical assault at workplace will not be taken as serious misconduct. This is because, in my humble view, truancy by an employee is of such a nature as to undermine the relationship of trust and confidence supposedly existing between the employer and the employee. This is not, however, to say that the dismissal of claimant is justified or in line with the principles of fair hearing. Just a minute. Now, there is no doubt that the claimant was issued with a query in respect of his misconduct for physical assault on his colleague, which has risen supra, in my respectful view, can be termed serious misconduct in line with the clause on dismissal of Exhibit A, E1, earlier reproduced in this judgment, and he responded to the query. As born from the Apex Court decision in the case of Imonike and Unity Bank PLC, citation captured, Rose Vivor GLC, now retired, held that accusing an employee of misconduct and so on by way of a query and allowing the employee to answer the query, and the employee answers it before a decision is taken, satisfies the requirement of fair hearing or natural justice. See also the case of FBN and Akmonji, citation provided, Raji and Wema Bank, citation equally provided. However, it is noteworthy that allegation of physical assault, which was the most recent of all claimant's queries and which he responded to in the spirit of fair hearing, is not the reason given for claimant's dismissal in Exhibit C1. As stated earlier, claimant was dismissed for truancy and low job performance, as seen in Exhibit C1, that is the letter of dismissal. Another word for truancy is absenteeism or opportunism. Absenteeism, also known as truancy, is one of the misconduct listed in Exhibit AE1 for which an employee may be dismissed. I must say that, as reasoned above, the most recent of the queries which was issued in 2017 was for physical assault, which is not the same as truancy, or absenteeism or low job performance, which were the reasons given for claimant's dismissal. It is equally an integral requirement in our labor jurisprudence that though an employer in an employment that is not with statutory flavor, as in this instance, is not obliged to give reasons for the termination of the employment of an employee. However, where it is dismissal, which implies some wrongdoing on the part of an employee, the employer must give reason for such, and he must justify the reason to the satisfaction of the court. See the case of Mwechi and Union Bank, citation captured, Keystone Bank PLC and Yigon, citation provided, UTC Nigeria Limited and Peters, citation also provided, SPDC Limited and Olarewaju, citation captured, the notorious case of Olani and others, and Unilag and another, citation provided. The employer justifies the reason given by showing that the employee committed in misconduct and he was afforded an opportunity to defend himself in line with the principle of fair hearing before he was dismissed. I'm mindful of the fact that some of the queries tendered in this case as part of a bundle of documents that make up Exhibit C3, which were issued on 12th of May 2014 and 12th of June 2014 respectively, and relate to claimants leaving his duty post without taking permission and absenteeism, which claimant responded to. I'm also mindful of the fact that claimant was issued a letter of warning on 23rd June 2014 on regular absenteeism. But then this court believes that those queries or warning letter are too remote to sustain the allegation of truancy in claimant's letter of dismissal. Put differently, this court does not believe queries given as far back as 2014 and which claimant responded to, and the warning letter given in 2014 after claimant was still allowed to remain in employment until it was dismissed in October 2017, will be the reason for claimant's dismissal. I do not share the sentiments of Learned Defense Counsel in paragraphs 4.7 to 4.8 of his final written address that seem to suggest that those queries of 12th of May and 12th of June 2014 respectively, or warning letter of 23rd June 2014, which he erroneously referred to as the query, is enough to justify the dismissal of claimant. I'll proceed to explain why. By the doctrine of implied waiver and condonation, the defendant is deemed to have overlooked the said absenteeism of claimant as covered by those queries and warning letter of 2014, and as such cannot be the reason for claimant dismissal in October 2017. In my view, the defendant having not taken any further step after the receipt of claimant answers to the query in 2014, and after the issuance of the warning letter, and allowing the claimant to continue work afterwards till 2017, seems to have condoned the alleged acts of misconduct, for that was treated with just touching of the wrist of the claimant. In the case of Ekundaya and University of Ibadan, citation provided, the court, while relying on the case of Electricity Corporation of Nigeria and Nicole, Supra, held that if after the knowledge of fraud committed by an employee, the employer elects to retain him in his service, the employer cannot at any subsequent time dismiss him on account of that which he has waived or condoned. See also the case of Benue State University and Mogaji, citation capture Lawrence Demudia, Omohale and Lasso, citation capture ACB PLC versus Imbisike, citation capture. In the case of Electricity Corporation of Nigeria and Nicole Supra, which was relied on by the court in Ekunda and University of Ibadan Supra, the acts of misconduct given as the reason for the respondent's dismissal had occurred a few years back when he was acting as the secretary of the corporation, the employer. But the misconduct was not revisited until after the same employer had promoted him to the substantive position. The court reviewed that as condoning the misconduct and held that the appellant could not have been dismissed for the same offense which has been condoned. All I'm saying is that the allegation of truancy, also known as absenteeism, is not a new allegation as claimant has been queried for it in time past. The question one might ask is, since it was condoned by the overt act of the defendant allowing claimant to stay in the employment even after the said queries, what makes the defendant think he would keep raking up allegations that were treated and condoned as if it was acting on this desperation to dismiss claimant? This fact is underscored by the fact that even Learned Defense Counsel agreed at paragraph 4.8 of his final written address that the defendant did pardon claimant severally, although he argued that such does not amount to condonation. With respect, it is a misconceived argument on the part of Learned Counsel for the defendant to say that pardoning claimant for the previous acts leading to the previous queries does not amount to condonation. Since Learned Counsel agreed that claimant was pardoned severally, that is an act of condonation. The Apex Court had, however, delineated the limits of condonation in the case of Nigerian Army versus Amin on Kano, citation provided per Muhammad GSC, who stated those, I quote, "I think we need to seek for the definition of the word quote and unquote condone, or condone, which literally means to pardon, to overlook as offense, to forgive, or to act so as to imply forgiveness. Thus, condonation is the act of condoning or pardoning a wrong act, the implied forgiving or pardon of an offense by overlooking it, unquote." Again, the Apex Court in the case of PML Nigeria Limited and FRN, citation provided, defines condonation thus, I quote, "Quote and unquote condonation is a voluntary overlooking or pardon of an offense," unquote. It is thus clear from the above decision of the Apex Court that once an act is pardoned, it is deemed condoned. I'm therefore surprised to see Learned Counsel argue that even though the defendant had pardoned claimant severally on the allegation of absenteeism or truancy, it never condoned same. Again, Learned Counsel, in support of his submission, had relied on the case of ECN versus Nicole Supra, but I must say that Learned Counsel misconceived the decision of the Apex Court in that case, in that the Apex Court was clear in that case that where the misconduct had occurred a few years back, and the employer did not take an immediate step, it could not revisit the same as that would amount to condonation. The defendant's step in respect of the alleged misconduct which was taken and which, according to the submission of Learned Counsel in paragraph 4.8 of his final written address, will amount to condonation, was only taken 3 years after the queries and answers, which was similar to what happened in the case of ECN and Nicole supra, and in which case the court viewed the act of the employer as condonation while affirming the decision of a trial judge with this same. One might want to say that claimant did not plead waiver of the misconduct or condemnation of the acts alleged for the court to be raising same, or that the court is making a case for claimant. It must be categorically stated that a party need not plead a particular word before the court can apply legal principle based on it. Claimant, by paragraph 7 of his reply to the statement of defense, averred that all the queries given to him were satisfactorily answered by him, and based on this, he continued work thereafter until his dismissal. In fact, DW, while under cross-examination, confirmed that claimant was given queries, which he answered and continued his work. Therefore, there is no doubt from the facts and evidence before this court that even after those queries in 2014, claimant continued work until his dismissal. This court is a court of law and has unfettered right to apply legal principles that fit into facts laid before it. A judge is not only bound by the submission of parties, he can apply law and authorities discovered even from his personal research. I rely on the decision in the case of Benue State University and Mogaji Supra, the case of Onwara and the state's citation captured. Since the issues of the queries and the later letter of dismissal, and the fact that claimant, even after the said queries continued work until his dismissal existed in litigation before this court can apply any applicable legal principles to it, because this court, by virtue of its adjudicatory functions and powers, can draw inferences from stated facts and evidence in the case, and by such inferences arrived at a conclusion. See the case of Ata Nigeria Limited and Corn Oil PLC, citation provided. Olorun Kunle and Adigun, citation captured. The case of Kenta Best Nigeria Limited and Attorney General River State, citation also provided. More so, since the Learned Defense Counsel in paragraph 4.8 of his final written address did raise the issue of pardon of the claimant by the defendant for the said acts, all I'm saying is that this court does not share the sentiments of the defendant that the queries and warning letter issued as far back as 2014 can justify the allegation of truancy stated in the claimant's letter of dismissal. Since the defendant had condoned the earlier allegation in the queries and warning letter, it could not be said that he has justified the allegation of truancy against claimant by giving him fair hearing. Claimant ought to have been confronted with a fresh allegation of truancy or absenteeism, which he would be requested to respond to before the defendant could dismiss him for truancy or absenteeism. Thus, claimant was not given fair hearing in respect of the allegation for truancy in his letter of employment, since the earlier ones covered by the queries of 2014 are deemed condoned. In another light, the other reason given for claimant dismissal was low job performance, which rightly is one of the reasons for dismissal in line with the dismissal clause in Exhibit A(E)(1). I must say at this stage that none of the queries that forms part of Exhibit C3, either the one given in 2014 or the most recent one in 2017, relates to either low job performance, which was the reason for claimant dismissal. The query in 2017 on physical assault cannot sustain the allegation of low job performance in the letter of dismissal. The defendant cannot charge claimant on allegation of physical assault, which he responded to, and then dismiss him for infractions on truancy and low job performance, which he was never confronted with, since the earlier infraction of truancy had been waived or condoned. See the decision of this court in an unreported suit number NICN/ABJ/65/2018, the case of Mr. M.H. Roma and Fort Oil PLC, a judgment delivered on the 2nd of May 2019. Thus, I agree with the position of claimant in his pleadings that he was never confronted with the allegations for him to defend himself. Also, as rightly submitted by Leonard Claimant's counsel in his final written address, the defendant has not placed the performance sheet or score sheet of a claimant that it ought to keep in line with the provision of Exhibit AE1 to show that claimant was truly liable for continuous below average performance. In law, where an employer fails to afford an employee an opportunity to defend himself before dismissal, as in this instance, the dismissal where the employment is not one with statutory flavor is deemed wrongful. What I'm trying to say is that in a master servant employment, as in this instance, even where the employer dismisses an employee without fair hearing, such dismissal is deemed wrongful and cannot be declared null and void. This is because in labor law, where an employer in a master servant employment dismisses an employee in breach of fair hearing or without following the procedure laid down in the condition of service, the dismissal stands, albeit wrongful. The court cannot pretend that the relationship continued because it was wrongfully brought to an end. The fact is that it was brought to an end, though wrongfully. The court does not have the jurisdiction to declare such dismissal null and void and of no effect, or to quash such wrongful dismissal as the claimant will want this court to do by his reliefs A and C. See the case of Ariba Tesdal PLC and Samuel and others, citation captured. Case of Oshisanya and AfriBank Supra, Supra. Case of Sakwe and Nigerian Paper Mill, citation provided. It is in the light of this that the court finds that relief A succeeds only to the extent that the claimant's dismissal was in breach of the rules of natural justice and thus wrongful, while relief C fails in its entirety. I so hold.
Add the court, please.
Claimant by relief B is seeking for a remedy of reinstatement and that all his salaries be paid till date. There's no doubt that this remedy is dependent on relief A, which seeks to nullify the dismissal of claimant. An employee in a master servant employment whose dismissal was done in contravention of the rules of natural justice, as I've stated earlier, cannot get a remedy of reinstatement. All that such an employee is entitled to would be a remedy in damages. This is simply because the court does not have jurisdiction to compel an employer to retain the services of an unwanted employee or to impose a willing employee on an unwilling employer. He is only liable in damages. See the case of NBC PLC and EPO, citation captured. Total Nigeria PLC and IEM, citation provided. At TV and Cabal Metal Nigeria Limited, citation provided. UBN Limited and Ogo, citation provided. In fact, the above is underscored by the fact that claimant himself, while under cross-examination, stated categorically that he does not even want reinstatement, that he is claiming for the sum of 198,333 naira instead, and which amount he stated that he arrived at by multiplying his monthly salary of 28,333 naira by the number of years he spent in the defendant. The point I'm trying to make here is that claimant cannot get the remedy of reinstatement, and he himself even said he does not want such remedy, which means that he was just asking it for the fun of it. Again, as regards the other leg of his claim, that all his salaries be paid till date, it needs to be pointed out that the law is on a firm pedestal, that a servant will only be paid for the period he served his master. Thus, an employee cannot claim for salaries for work not done. See the case of CCB Nigeria Limited and Nwanko, citation captured. Balogu and Union Bank, citation provided. Ulatubosa and NISA, citation also provided. Claimant stated categorically while under cross-examination that since his dismissal, he has not stepped foot in the defendant's company, which means that since then, he has not worked for the defendant. In line with the above principle of law, claimant cannot therefore claim for salaries for the period after the determination of his employment. It is thus clear that this other leg of claimant's claim in relief B cannot equally succeed. It is in the light of the above reasoning that I find that relief B also fails in its entirety. Claimant by relief D is claiming for the sum of 5 million naira as damages for unlawful termination of employment. First, let me say that what we are faced with in this case is not termination, but a dismissal. Termination and dismissal are not the same, though both signifies cessation or severance of employment relationship. Howbeit, I've reasoned supra that the remedy of claimant for wrongful dismissal by the defendant lies in damages, as claimant cannot get a remedy of reinstatement. Ordinarily, all he gets as damages is the amount he would have earned if his employment had been properly determined. That is, how much he would have gotten over the period of notice. Therefore, such an employee may be paid a month's 2 months, 3 months salary in lieu of notice, depending on the term and condition of service between the parties. Where no period of notice is stipulated or agreed upon by the parties, then the law stipulates that he has to be given reasonable notice, which has to be determined by the court. However, in recent times, in view of international best practices, the quantum of damages assessed at common law is no longer fashionable, especially where the dismissal is for a reason which carries some stigma or on the personality of the employee. In fact, courts have made a case for substantial damages where applicable, therefore shifting progressively from the common law orthodoxy of quantum of damages payable. In the case of British Airways and Lakoja Supra, which was relied on by Learned Claimant Counsel in his address, the court per Bazonu JCA affirmed the award of 2 years' salary as damages by the trial court. In the said case, it was held that the quantum of damages recoverable by an employee depends on whether the wrongful termination of employment was as a result of failure to give the required notice or as a result of an alleged malpractice. And if the former, the quantum of damages may be the employee's salary in lieu of notice, but if the latter, then since such termination carries with it some stigma on the character of the employee, he shall be entitled to substantial damages far beyond the payment of salary in lieu of notice. Incidentally, the court in the case of Sahara Energy Limited and Oyebola citation captured Ogaku JC, while relying on the case of British Airways and Lakoja Supra, recognized the power of this court to apply international best practices in labor and therefore affirm the award of 2 years' salary of the employee as substantial damages. The defendant in this case gave truancy and low job performance as the reasons for the dismissal of claimant, which no doubt carried some stigma on the personality, the ability, and career of the claimant, and which reasons they have not been able to justify before this court for reasons given earlier. Besides, this court is empowered by Section 19D of the National Industrial Court Act 2006, also known as NICA, to award compensatory damages in deserving cases. In exercise of the powers granted this court under Section 19D of NICA 2006, and the powers granted this court by Section 254C1, paragraph F of the Constitution of the Federal Republic of Nigeria, 1999, as altered, that I award the claimant 6 months' salary as damages. Claimant, by his own challenge, averment stated that he earns the sum of 28,233 naira as monthly salary, which, when multiplied by 6, will give a total sum of 169,398 naira. More so, claimant has averred that he is entitled to the sum of 193,000, which is his benefit for the 7 years he spent in the defendant, and which sum the defendant, by its statement of defense, is saying the claimant is not entitled to because he was dismissed. In fact, the defendant, by paragraphs 4.17 to 4.18 of its final written address, admitted that even if claimant dismissal is found wrongful by the court, all the claimant will be entitled to is the sum of 198,333 naira. This, to my mind, presupposes that the defendant is willing to pay claimant that amount should his dismissal be declared wrongful. I say so in view of the fact that it is the belief of this court that the admission of Learned Defense Counsel binds the defendant. See the case of Okusanya and others versus Adetona and others citation captured. Ingu and others and Oniegbo and others citation provided, and the case of Ataki and Afejiku citation provided. A court of law can award less than a sum claimed by a party, but cannot award more than what was claimed, as the court is not a Father Christmas. Consequently, in view of all reasons, Supra award the sum of 169,398 naira, being claimant's 6 months' salary as damages for wrongful dismissal. I so award. Claimant by Relief E wants the court to award him the sum of 5 million naira against the defendant for attaching this insignia or dismissal on him. The same amounts to stigmatization. I have in the preceding relief awarded claimant damages for wrongful dismissal. I cannot by this relief be awarding claimant damage for attachment of insignia of dismissal for the same wrongful act of the defendant which claimant has been compensated for in the preceding paragraph. To proceed to assess damages simultaneously on each of the two items of general damages in respect of the same cause of action resulting from one and the same incident. By the law against double compensation, a party who had been fully compensated under one head of damage for a particular injury cannot be awarded damages in respect of the same injury under another head. See the case of Blue and another and Jamii, citation provided. GC Nigeria Limited and Trade Bank PLC, citation provided. Tokwa Motors Nigeria Limited and UBA PLC, citation provided. To proceed to assess damages simultaneously on each of the two items of general damages and reliefs D and E, in respect of the same cause of action resulting from one and the same incident, or springing from the same stream, will amount to double compensation. Relief E is thus refused.
The court, please.
The claimant in his relief F is asking for cost of litigation. Before now, the position as laid down in the case of Guinness Nigeria PLC and Nwo case citation captured is that it is an affront to public policy and unethical for a party to transfer the burden of his solicitor's fees to the opposing party. However, the position now as seen in the decision of the Apex Court in the case of Mekwe and Emirates Airlines, citation provided, is that award of costs, including cost of litigation, is at the discretion of the court. Once empowered by its rules, that is, its civil procedure rules. See also the case of Kappa and Alberto Nigeria PLC and NDIC, citation provided. This court has similar provisions as that of the Federal High Court relied upon by the Apex Court in the case of Mekwe Supra. The rules of this court, particularly Order 55, empowers this court in exercising his discretion in the grant of costs, to grant costs of action. The discretionary power of the court is to be exercised judicially and judiciously. The claimant in this suit did not assess the cost, rather he passed the burden on the court. Considering the history and length of this case, the number of appearances in the case, the number of processes filed, I will in my discretion award the claimant a reasonable cost. I hereby award the sum of 250,000 naira as cause of action in this suit. I so award. I'm, however, mindful of the fact that claimant has risen supra-sought reliefs in the alternative to the above reliefs. It is the position of the law concerning alternative reliefs that alternative reliefs will only be considered where the main claim cannot be granted or fails. On this, see the case of Usuji and Lakoja, citation captured. MV Caroline Maersk, sister vessel to MV Christian Maersk versus Nokoi Investment Limited, citation provided. Case of Idigbe and Idigbe, citation captured. Yesuvan Cooper International NVE, citation provided. The court has granted the most part of the claimant's main reliefs A to F. There will be no justification for this court to still consider claimant's reliefs A to F, which was sought in the alternative. Below, before I draw the curtain on this judgment, let me quickly address certain things from the final written address of the claimant in this case. Counsel had in paragraph 6.5 therein cited the case thus: Coca-Cola Nigeria Limited and others visited Akisoya on reported SC 542/2013. The law is settled beyond peradventure that where a counsel cites a case, he must do so with clarity, and where he cites an unreported case, as in this instance, he must furnish the court with a CTC, that is a certified true copy of same. See the case of Chidoka and another and First City Finance Company Limited, citation captured. Counsel failed to do this in this case. This court takes judicial notice of the fact that the case he even sought to cite, which is the case of Coca-Cola Nigeria Limited and Titila Akisaya, has a citation, which is 2017 Nigeria Weekly Report, part 1593, page 74. Counsel still cited wrongly the citation. Counsel has to bear in mind that he owe a duty to a court to properly cite the cases he seeks to rely on in his briefs of argument in order to assist the court. Again, it is noteworthy that counsel was in his conclusion in his final written address submitting that claimant is entitled to be paid his pension contribution benefit, as he alluded to the fact that they have a pension contribution scheme and his employer has failed to furnish to the pension fund administrator his pension. I carefully considered the whole of the claimant's pleadings from his statement of facts to his reply to the statement of defense. There was nowhere claimant pleaded the issue of his contributory pension. It is well settled that in adversarial civil litigation, as in this instance, cases are fought basically on pleadings of parties. Thus, the pleading of parties must state comprehensively the material facts so as to ascertain with certainty and clarity the matters in dispute between parties. This is to ensure adequate notice is given to the other party as to the issues he needs to respond to avoid the element of surprise and bring to the knowledge of court the essential facts in the case. See the case of Wala Hassan and another Anishaku and other citation provided. The case of Odom and others and PDP and other citation provided. Shodikwa and Lemmy Canning and another citation provided. I do not feign ignorance of the fact that Leonard Claimant Counsel did cross-examine DW on pension contribution. It needs to be stated that evidence elicited under cross-examination is only relevant where parties have pleaded it in their pleadings. In the case of Agbo and Ikewibo, citation provided, the Supreme Court held that the law is that the evidence elicited during cross-examination is not inadmissible merely because such evidence is not supported by the pleading of a party eliciting the evidence, and that it suffices if the evidence is pleaded by either of the parties to the suit. However, in this instance, none of the parties even pleaded any fact relating to pension contribution.
Okay, it's fine.
Counsel to be cross-examined. DW2 on same. Please mute your system. Mute your phone. It is for this reason that this court did not give.
No, okay.
Please mute your phone if you're online. Please mute your phone if you're online. If you're hearing this, your phone. It is for this reason that this court did not give credence to that evidence elicited from DW under cross-examination. Again, I do not know what the Leonard Counsel would want the court to do with his submission above in the final written address as regards claimant's entitlement to pension contribution, since claimant in his main and alternative reliefs never sought any relief claiming for his pension contribution. A court of law is always restricted to what is claimed before it. Put in other words, a court has no power to grant to a party what it has not asked for or to award more than what is claimed as elucidated above in this judgment. See the case of Bakari and Ogundikwe citation provided, Dantata and Sawo Construction Company Limited and Ibrahim citation provided. In fact, this settled position of the law was aptly captured in paragraph 4.20 of the final written address of the defendant. The court has no jurisdiction to award what is not sought for by a claimant.
The court pleases.
Counsel should be reminded that a final address cannot expand, extend, or make a new case outside of the pleadings and evidence adduced by parties upon which they founded and predicated their respective cases before the court. See the case of Mobi Producing Nigeria Unlimited and INE and others citation captured, Busari and others versus Hosseini and others citation provided. Final addresses by counsel in the case are designed to assist the court in readily ascertaining the materials and relevant issues in the case and not to make or introduce new issues like that of a claimant's entitlement to pension contribution. The above explains why the court gave no thought or consideration to the issue of claimant's contributory pension in the evaluation of this case. For the avoidance of doubt and reasons earlier given, this court declares and orders as follows. 1, that the dismissal of claimant in breach of the rule of natural justice or fair hearing is wrongful. B, that claimant is entitled to be paid the sum of 169,398 naira as damages for wrongful dismissal. C, claimant is entitled to be paid the sum of 250,000 naira as cost of action in this suit. And D, this judgment is to be complied within 30 days of delivery of same, failing which it shall attract 10% post-judgment simple interest. Judgment is accordingly entered.
The court, please. Lord, we are most and very sincerely, sir, grateful for this erudite and always well-detailed and well-considered judgment. My Lord, we are bound by this judgment and we shall abide by it. It is, we do not think we can get something better than this. We are most grateful, sir. Very, very grateful. It is detailed. It is the law. My Lord, it is the law. Thank you very much, sir.
Thank
my Lord,
you.
I'm sorry, sir. Two of my colleagues, they couldn't log in when I was announcing, but eventually they logged out. If my Lord will kindly allow me to mention their name, sir. Thank you, sir. My Lord, with me is M.A. Shehu Esquire. M.A. initial, M.A. Shehu. And C.N. C as in cat, N as in Nigeria. C.N. Anyika. My Lord, Anyika is A.N.Y.I.K.A. Esquire.
Well.
Yes, my Lord, we sincerely thank your Lordship, sir, for this erudite judgment. Your Lordship has accurately stated the position of the law. We are bound by it, and we shall abide by it. Thank you very much, sir. We shall comply, sir. We are most grateful.
So you will receive a clean copy. I only observe little typos, which will be corrected and pass on to you.
Yes, sir. We are grateful, sir.
Thank
you. Yes, sir.
Call the next case, Lakoja.
I don't know if my Lord will permit me to take my leave, sir.
Yes, please. You are free to go ahead.
I'm
you can
grateful,
exit the courtroom.
Thank you, sir.
Very well. Call the next case, Court Registrar.
NICN LKJ 13/2022 between Onoja Alaju Oguche and Kogi State Government and 3 others. My Lord, the claimant is in court. Defendant's absent.
Appearances.
The claimant represents himself. The claimant proceeds with his case.
Any other appearance? Any other appearance? Any appearance? Any appearance?
Earlier on, seems he has gone off.
The defense counsel?
Yes, my Lord.
But they are aware?
Yes, he was earlier online, my Lord.
Okay, you can unmute yourself and let him know that the court is delivering its judgment now.
Of the court, please.
Here is the judgment of the court. Like I said earlier on, please mute your phone, your tablet or system. The claimant's case, as could be gleaned from his statement of claim, is that his late brother, late Sule Onoja, was initially employed by Benin State as a driver on temporary appointment, was redeployed to the first dependent Kogi State government upon the creation of the new state in 1991, where his appointment was later confirmed. He served in the Ministry of Justice and then Ministry of Environment and Physical Development until his death while in active service. He further averred that in November 2011, the third defendant invited all pensioners across the state and administrators of estate of deceased persons entitled to death benefit for which his late brother belongs, and the verification was successfully carried out. He stated that the Kogi State Auditor General's Office, in due compliance with necessary requirement, computed the death benefit to be the sum of 972,291 naira 68 kobo. However, out of the above sum, only 150,000 naira was paid at 3 installments, leaving an outstanding balance of 822,291 naira 68 kobo. He also averred that he repeatedly visited the third defendant for the outstanding balance till 2016 before the third defendant mentioned that the first defendant is largely responsible for the non-payment due to lack of funds. He continued that around September 2016, he was assured it will be paid once the CBN bailout funds of over 50 billion naira is released. But when the fund was released, the first defendant failed to pay the deceased outstanding benefit despite countless visits to the third defendant's office. It is against this backdrop that claimant on 28th of June 2022 took out a general form of complaint against the defendants, praying the court for the following reliefs. A, an order of this court declaring illegal, unlawful, null and void, unconstitutional, all that acts of the defendants that undermine the proprietary rights of the claimant's late elder brother, children to the death benefits, gratuity, allowances yet unpaid, with thereto violate, threaten to violate, and is likely to further violate the proprietary rights of the children of the claimant's late elder brother, without due regard to the claimant's right as administrator, to be wrongful, illegal, null and void, devoid of constitutional principles, and against the rule of law. B, an order of this honorable court declaring illegal, arbitrary use of official powers, unconstitutional, null and void, the act of the defendant's arbitrary, willful, and careless refusal to pay off the balance of 822,291 naira 68 kobo, being the outstanding money to the credit of his gratuity and death benefits allowances between the years of 1987 to 2004 as at death, and duly acknowledged by the officers of the defendant as owed the estate of late Sule Onoja, claimant's late elder brother. In the schedule captured and presented to the third defendant in computation of pension gratuity file number 608, yet unpaid based on no just cause since the period of about 2009 hitherto, which wrongfully deprived the late Sule Onoja's children an economic value and usage of their late father's earned money and allowance, and thereby caused them immeasurable financial loss, economic hardship, torture, trauma, and lack of funds to attend to their immediate financial needs. And C, an order declaring illegal, void, null, and unknown to law, and lack of legal procedure and arbitrary use of official powers of the defendants with due regard to law and in violation of the late Sule Onoja's children fundamental rights to movable property, to wit, and death benefits as computed by Auditor General's Office of the Defendants, contrary to sections 33, 34, 43, 44, 1 and 2, 254C of the 1999 Constitution of Federal Republic of Nigeria as amended, Articles 2, 3, 4, 5, 7, 8, 9, 10, 11, 15, and 17 of the African Charter on Human and People's Rights, Ratification and Enforcement Act, Cap 10, Laws of the Federation, 1990. D, an order of this court directing the defendants to pay up the total sum of 822,291 naira 68 kobo, being the outstanding balance of the debt or gratuity benefit of late Sule Onoja yet unpaid, for benefits of the heirs to the breach of the fundamental rights to life of the children of late Sule Onoja, as guaranteed by sections 33, 34, 43, 44, 1 and 2, 254C of the Constitution, and Articles 2, 3, 4, 5, 7, 8, 9, 10, 11, 15, and 17 of the African Charter on Human and People's Rights, Ratification and Enforcement Act, Cap 10, Laws of the Federation of Nigeria, 1990. E, a declaration that the joint actions of the defendants refusal to pay off the total sum of 822,291 naira 68 kobo, being the end outstanding balance of debt gratuity of late Sule Onoja in Pension Office computation file number 608, is in violation of the children's fundamental right to earn wages as movable property or properties as guaranteed by sections 33, 34, 43, 44, 1, and 2, 254C of the Constitution of Federal Republic of Nigeria, as amended Articles 2, 3, 5, 4, 5, 7, 8, 9, 10, 11, 15, and 17 of the African Charter on Human and People's Right Ratification and Enforcement Act, Cap 10 Laws of the Federation of 1990. F, a declaration that the unlawful action of a defendant is direct attack aimed against the children of late Sule Onoja's fundamental right to means of livelihood, smooth operation, and peaceful management of their low but simple lifestyles to health, family needs, and thereby cause them economic paralysis, untold hardship, shock, trauma, loss of money, breach or infringement of their right to human entrepreneurship by disorganizing, disorienting their numerous business and financial activities. G, an order awarding the sum of 3 million naira to the children of the late Sule Onoja being damages suffered from the shock, trauma, mental torture, and illegal deprivation of access to their end death benefits of their late father from 2004 hitherto by the third defendant, and the usurpation of the free use of their father's end death benefit to attend to their immediate family needs, health issues, business plans, and financial organization. 2, the defendant's arbitrary and unlawful use of power to breach or cause of infringement on the right to their means of livelihood. 11, H, general exemplary and aggravated damages of 1 million naira against the defendant for the arbitrary infraction, threat to further infraction on the propriety and fundamental rights of the late Onoja's children. I, 500,000 naira being the cost of prosecuting this suit by the claimant with 10% post-judgment interest rate pending full payment. In response to the claimant's statement of claim, the defendants filed a joint statement of defense where they jointly averred that upon notification of the death of a deceased, the third defendant processed his death benefits, and based on calculations from the Office of the Auditor General of Kogi State, the total benefits accruable to the deceased is the total sum of 972,291 naira 68 kobo. They further averred that the third defendant commenced payment of a deceased gratuity of a sum of 350,000 naira, with a balance of 662,291 naira 68 kobo left to be paid. They stated that the increasing number of retirees and pensioners in the state and the harsh economic conditions being faced, among others, affected the processing of payments to the deceased beneficiary, as the last payment made to the beneficiary was based on the availability of funds, as there are several thousands of pensioners and beneficiaries whose benefits are pending. Also filed by the defendants is a notice of preliminary objection on the 29th of August 2022, praying the court for 1, an order of this court dismissing and or striking out the suit, and 2 is an omnibus prayer. The grounds upon which the application was brought are 1, that the principal claims of the claimant are fundamental rights and not justiciable in this suit, which renders the suit incompetent. 2, by virtue of Section 46 of the Constitution of Nigeria, 1999 as amended, and the Fundamental Rights Enforcement Procedure Rules 2009, this honorable court lacks jurisdiction in this case. 3, the subject matter of the suit does not fall within the purview of Section 254C and Section 7 of the National Industry Court Act. 4, the suit discloses no reasonable cause of action. Accompanying this application is a 4-paragraph affidavit deposed to by one Ejura Pe, a civil servant in the Ministry of Justice, and also filed is a final written address. A written address in support. I reduced the arguments into the body of this judgment. In response to this application, claimant filed and deposed to an 18-paragraph counter affidavit, and also filed written submission. I've reduced all that into the body of this judgment. In the course of trial, claimant testified for himself as CW adopted his sworn deposition, and tendered documents admitted the matter as bit A to A9. He was cross-examined by defense counsel. Subsequently, defendants called their sole witness, one Mr. B.B. Adayi, who equally testified by adopting his sworn deposition. He tendered documents admitted the matter as bit B to B1. And parties at the close of trial filed their respective final addresses. I've reduced that into the body of the judgment. So I will now go on straight to the decision of the court. An in-depth consideration of the processes filed by parties in this suit, including the notice of preliminary objection, means that the issues due for the determination of which will meet the justice of this case are whether in view of the facts of this case, this suit is competent as constituted, and thus clothe this court with requisite jurisdiction to entertain same. And if this is answered in the affirmative, 2, whether the documents tendered by claimants are admissible in evidence, and 3, whether on the balance of probabilities, the claimant is entitled to the relief sought in this case. Respecting issue 1, it is the contention of the defendants that this court lacks jurisdiction over the claim of the claimant, as this court does not have jurisdiction over fundamental human rights. The law is long settled that when the issue of the court's jurisdiction is raised, the court must consider such first before it goes on or proceed to consider the merits of the case. The duty of the court in such instance is to expound on its jurisdiction, but not to expand it beyond the scope provided in statute. See the case of Jacob and Commissioner, Ministry of Environment and Mineral Resources, Akwa Ibom State, and another citation captured. Musa Koni Limited and Aspinal citation provided. Leelu Habib and another versus AG Federation and other citation captured. Tukor and Governor of Gongola State citation provided. African Newspapers, Nigeria Limited and FRN citation captured. It is pertinent at this juncture to consider the provisions of Section 254C1, paragraphs A to D and K of the Constitution of the Federal Republic of Nigeria as amended, which is hereafter referred to as the Constitution, as they relate to the jurisdiction of the court. Thus, Section 254C, subsection 1 provides that notwithstanding the provision of sections 251, 257, 272, in anything contained in this Constitution, and in addition to such other jurisdiction as may be conferred upon it by the National Assembly, the National Industrial Court shall have an exercise jurisdiction to the exclusion of all other courts in civil causes and matters, A, relating to or connected with any labor, employment, trade unions, industrial relations, and matters arising from workplace, the conditions of service, including health, safety, welfare of labor, employee, worker, and matters incidental thereto or connected therewith. B, relating to or connected with any dispute over the interpretation and application of provisions of Chapter 4 of this Constitution as it relates to any employment, labor, industrial relations, trade unionism, employers association, or any other matter which the court has jurisdiction to hear and determine. Paragraph K, relating to or connected with dispute arising from payment or non-payment of salaries, wages, pensions, gratuities, allowances, benefits, and any other entitlements of any employee, worker, political or public office holder, judicial officer, or any civil or public servant in any part of Nigeria, and matters incidental thereto. It is handbook law that in the interpretation of statute, construction is to be made of all the parts of the statute together, especially parts dealing with same subject, and not one part only by itself. Put different, interpretation and construction of statutes should be holistic. That is, a provision of a constitution or a statute should not be interpreted in isolation, but within the central context of the constitution or statute as a whole. See the case of Jegede and another, and INEC and other citation captured, Minister of Petroleum Resources and another, this was SPDC, citation provided, National Union of Road Transport Workers and another, and Road Transport Employers Association, citation provided. It is clear from the holistic construction of Section 254C1 of the Constitution that deals with the civil jurisdiction of this court, that this court is vested with jurisdiction over employment, labor, trade union matters, including any dispute on the interpretation and application of Chapter 4 of the Constitution as it relates to any employment, labor, industrial relations, trade unionism, employers association, or any other matter which the court has jurisdiction. Thus, the court can entertain any matter that borders on the interpretation or application of provisions of Chapter 4 of the Constitution, which is obviously on fundamental human rights, so far as it deals with labor, unemployment, or trade unionism, or on any matter in which the court has jurisdiction to entertain. One of such matters on which the court's jurisdiction is overpayment or non-payment of gratuity and benefits, and any other entitlements of any employee as provided for in paragraph K of the Section 254C1 of the Constitution. Thus, this court can deal with any dispute on the interpretation or application of Chapter 4 of fundamental human rights as it relates to payment or non-payment of gratuity or death benefits. I peruse the claimant's claim, and it is as regards the propriety or otherwise of the defendant's refusal to pay the balance of the gratuity and death benefits of one Sule Onoja, who was an employee of a defendant, and that such violates the proprietary rights of the deceased children. I believe the misconception of learned defense counsel attacking the jurisdiction of this court in his preliminary objection, wherein he argued that the jurisdiction of this court is in respect of labor matters only and does not extend to fundamental rights, whether directly or indirectly, where quoting Section 254C1A and B of the Constitution, is born out of the fact that learned defense counsel failed to appreciate and consider the whole provision of Section 254C1 of the Constitution as they relate to the jurisdiction of this court, especially subsection 1D and K of Section 254C thereof. More so, the Apex Court has held in the case of Mwanze and NRC, citation capture, that where a claim falls within the jurisdiction of two courts, the court with jurisdiction over the main claim is the proper court to determine the matter. The Supreme Court in that case held that since the relief of the appellant on fundamental human rights cannot be determined in isolation of the two other reliefs in termination of his employment, the State High Court in that case lacked jurisdiction, and that the Federal High Court was the court with jurisdiction on both claims on fundamental human rights and termination of employment at the time the cause of action arose, since the employer was a federal government agency. Thus, the State High Court had no jurisdiction. The fact of the said case had happened before the Third Alteration Act that recognized this court as the court with exclusive jurisdiction on employment matters. The reason the Apex Court held that it was the Federal High Court and not the State High Court that had jurisdiction over the matters at that time. See also the case of Olayemi and Federal Housing Authority citation provided. The issue of the alleged breach of the proprietary rights of the children of the deceased by the non-payment of a remainder of the gratuity and death benefits of a deceased employee by the defendant is inextricably tied to the issue of payment or non-payment of the gratuity, and both cannot be separated. And this court by Section 254C1D and K has power to consider the application of the provisions of Chapter 4 of the Constitution to the dispute on non-payment of death benefit of a deceased employee at hand. I must say that it was wrong of learned defense counsel to argue as he did in paragraph 3.17 of his written address in support of the notice of preliminary objection that this action is a fundamental right action, and claimant can only come under the fundamental rights enforcement procedure rules alone. Let me say that it is not compulsory that when an action touches on fundamental right, it must be brought under the fundamental rights enforcement rules or procedure rules. On this, I would like to place heavy reliance on the case of Climax Hotel Nigeria Limited and another, and Beniti Global Nigeria Limited and others citation captured, where the Court of Appeal held inter alia and I quote, can it be heard to be saying that any relief that has a bearing on the infringement or breach of a person's right cannot be entertained by way of a writ of summons and statement of claim? If this is the contention of counsel, he appears to have totally misapprehended the law. The fact that averments in the plaintiff's claim touch on breaches to his fundamental human rights and alleges torture to his person and otherwise forms grounds for commencing an action under the fundamental human rights procedure does not stop him from instituting an action for damages for any breaches to his rights by way of an action by writ of summons. I hold a plaintiff whose rights have been infringed is not limited to seeking redress only under the fundamental rights enforcement procedure rules. He may wish to bring an action by other means, including by writ of summons against the offender. The whole purpose of enacting the Fundamental Rights Enforcement Procedure Rules 2009 is to protect the citizen against arbitrary arrest and detention by the government and its agencies, and also individuals. It provides a procedure for speedy intervention by the courts in protection of these rights involving the liberty of the individual, and is given priority over all other matters and heard immediately they are filed in court. It is not the position of the court that where fundamental human rights are infringed, the applicant must institute the action under the fundamental human rights procedure and no other. The procedure under the Fundamental Rights Enforcement Procedure Rules is merely to avoid the cumbersome process of a regular suit. The first and second respondents, I accordingly hold, were at liberty to choose to sue either under this procedure or by other action. The only stricture to instituting an action under the Fundamental Rights Enforcement Procedure Rules is that in order to qualify for that procedure, the principal relief should be for the enforcement of or securing the enforcement of this right. It is therefore a misconception of the law for the appellant counsel to contend that the reliefs claimed by the first and second respondents bordering on infringement of their fundamental human rights could only be brought under the Fundamental Rights Enforcement Procedure Rules and no other, unquote. Also, the court in the case of Ogian and other versus Governor Bayelsa State and other citation captured held that where an alleged breach of the fundamental right is ancillary or incidental to the substantive claim, it is incompetent to constitute the claim as one for enforcement of fundamental human rights. In that case, the appellant at the trial court sought the following reliefs. A declaration that the compulsory acquisition of the applicant's private secondary school or property by Bayelsa State government is a violation of their fundamental right to acquire and own immovable guaranteed under Section 43 of the Constitution of Federal Republic of Nigeria 99 as amended to a declaration that the compulsory acquisition of the applicant's private secondary school or property by the Bayelsa State government without paying them any compensation from 99 to date is a violation of the applicant's fundamental right to payment of prompt and adequate compensation guaranteed under Section 44(1)(a) and (b) of the Federal Republic of Nigeria 1999 as amended, as well as Section 29 of the Land Use Act 1978. 3, a declaration that a compulsory acquisition of applicant school without providing them with alternative accommodation or facilities to run their school deprive them of their means of livelihood or sustenance and therefore entitle them to compensation. 4, an order of the court awarding compensation in the sum of 100 million naira to the applicant's hearing to be paid en bloc by the Bayelsa State government by the respondent not later than 3 months from the date of judgment, and 5, 21% interest per annum from the date of the acquisition in 1999 till compensation is fully paid, unquote. The Court of Appeal in this case found that the main claim is for payment of compensation of 100 million naira and not the infringement of fundamental rights. That the infringement of fundamental rights is ancillary claim. In my opinion, the means, please unmute yourself. Please mute your phone. Mute your phone. Tunji Odiokaye, mute your phone. The Court of Appeal in that case found that the main claim is for payment of compensation of 100 million naira and not the infringement of fundamental rights. That the infringement of fundamental rights, the ancillary claim. In the same vein, in my unwavering view, the main or substantive claim of the claimant in this instance suit is for payment of the alleged unpaid remainder of the debt benefit or entitlement of the deceased employee by the defendants, because that is what this action seeks to achieve, while the claim that such non-payment violates the proprietary rights of the deceased children is the ancillary claim and not the main claim. The court cannot consider whether the non-payment constitutes a breach of the proprietary rights of the deceased children without first considering the issue of payment or non-payment of the said gratuity and that benefit first, and which claim is within the exclusive jurisdiction of this court. This is because the right, if any, violated is not synonymous with the substantive claim of non-payment of the remainder of the death benefits of the claimant's deceased brother, which is the subject matter of the action. Recognition of a right per se cannot resolve the substantive claim payment of the said remainder of the said benefit, which is in any case different. The main grounds as reason supra is for the payment of the remainder of the unpaid death benefit of the deceased. This is a matter that cannot be ignited as a fundamental right action under Chapter 4 of the Constitution and under the African Charter on Human and People's Rights. At best, the fundamental rights aspect is ancillary. It is thus my view in this case that it is wrong of counsel to constitute this claim as one for the enforcement of fundamental rights, which according to him, this court has no jurisdiction to entertain. This court is nonetheless the appropriate court to entertain claimant's claim. In fact, the court in the case of Ngwagbo and others versus National Intelligence Agency, citation captured, held that this court is the proper court before whom to claim entitlements of deceased employee in line with Section 254C, subsection 1, paragraph K of the Constitution, and the fact that the employment relationship has ceased because of death is of no moment. From the plenitude of the powers of this court, as can be seen from the relevant applicable portions of the Constitution reproduced supra, the authorities referred to and the facts of this case, it is obvious and crystal clear that this court has the jurisdiction, indeed exclusive one, to adjudicate claimant's action. In my view, to hold that a dispute on whether the provision of Chapter 4 on fundamental rights apply to the non-payment of death benefits of a deceased employee, considering the provisions of Section 254C, 1, paragraphs D and K, constitutes not within of the Constitution, is not within the jurisdiction of this court, is absurd. Just a minute. Thus, I find that the claim of the claimant is well within the substantive jurisdiction of this court and this court alone. It is equally the contention of the defendants, v. their preliminary objection, that this case discloses no reasonable cause of action. In fact, this was one of the grounds of objection in the defendant's notice of preliminary objection. However, learned defense counsel did not in his written submission in support of preliminary objection make any arguments in support of this ground of objection. He merely submitted those in paragraph 4.0 of the said written address at page 82 of the record of this court does, and I quote, conclusion. Finally, we submit that this suit discloses no reasonable cause of action. The suit is incompetent and the Honorable Court will lack jurisdiction in the circumstance. We urge the court to dismiss the suit, unquote. The whole of the said written address was on lack of jurisdiction because according to defendants, this court lacks jurisdiction to entertain an action on fundamental rights. There was nowhere counsel preferred arguments that the case of a claimant does not disclose reasonable cause of action. Ojo Okai Esquire only stated such passively in conclusion as captured above. The law is on the firm terra that where a party fails to advance argument in support of a point of objection, such objection is deemed abandoned. See the case of Kappa and Alberto Nigeria PLC versus NDIC citation capture, the case of Idigbe and Warren Refinery and Petrochemical Company Limited, and another citation capture that Jibadi and Pedro citation equally provided. It is thus without doubt that the legal consequence of failure of learned defense counsel to prefer arguments on the ground of objection that this suit discloses no reasonable cause of action is that same is deemed abandoned by counsel. Assuming an argument was even preferred in support of this ground of objection, I'm not sure same can be sustained. This is in view of the settled position of the law that though jurisdiction and reasonable cause of action are distinct, but they are interwoven. For without a reasonable cause of action, the court cannot exercise jurisdiction over the matter. However, lack of reasonable cause of action entails that the claimant also lacks local standing. Can it be said that claimant's action discloses no reasonable cause of action, which would also mean he lacked locus? It is settled that a cause of action constitutes a bundle of facts and circumstances giving rise to the plaintiff and possible claims against the defendant. The facts and circumstances have to be as pleaded in the statement of claim or its equivalent. And so it has to be ascertained by having recourse to the statement of claim. A cause of action which when only the allegation in the statement of facts or claim, and I may add originating process, are considered to have some chances of success, is deemed to be a reasonable cause of action. It is a statement of claim or its equivalent, as in this case, a statement of fact in an originating process that determines the existence or otherwise of reasonable cause of action. Put differently, a court has to examine a statement of facts or claim or its equivalent to reach a conclusion whether a suit discloses a reasonable cause of action or not. So the case of Opia and INEX citation captured, Nwazoroye and Governor of Imo State citation provided, Chevron Nigeria Limited and LD Nigeria Limited citation provided, 7-Up Bottling Company Limited and Abiola and Sons citation provided. A claimant's action is said to have a cause of action when his pleadings reveal that there has been an infraction or trespass to his rights and obligation. That is to say, there must be a cause of complaint, B, a civil right or obligation fit for determination by the court, and C, the issue must be justiciable. It must be clearly seen in the pleadings, the wrongful act of the defendant, which in effect gives the claimant his cause of complaint and the resultant damage from the defendant's wrongful act. I peruse the averments in the statement of facts of the claimant, which is an equivalent of a statement of claim. It is clear therein that the claimant is claiming for the alleged unpaid balance of the gratuity of his late brother, one Sule Onoja, who was an employee of the defendants, and is claiming such in his capacity as the administrator of the deceased estate, and alleging that failure to pay the said balance by the defendants amount to a breach of infringement of the proprietary rights of the deceased children who are beneficiaries of his estate. There's a question fit to be tried by this court. And I will be surprised if an action brought by an administrator of the estate of the deceased to claim for the payment of the deceased gratuity and death benefit is said not to have a reasonable cause of action. To say that the claimant's action has no cause of action is to also say that claimant has no cause to bring this action. See the case of Nwazoroye and Governor of Imo State Supra. In fact, children or widow of the deceased, whether or not they have been officially issued with a letter of administration of the estate by the government, can bring such action. And the action will not be said to be without reasonable cause of action or local standing. It is the belief of this court that even by tradition or convention, members of the deceased family have equitable right and interest to protect the deceased estate, even while awaiting a letter of administration where applicable. This action, which is meant to protect the deceased estate by claiming his unpaid gratuity and death benefits from his employers, is no doubt one with reasonable cause of action, and this court cannot find otherwise. In view of all reasons, Supra, I'm of the unshaken view that this court is imbued with the necessary jurisdiction to try claimant's case, as the subject matter is within the substantive jurisdiction of this court, and there is reasonable cause of action therein. Question 1 is thus resolved in favor of the claimant. Now to issue 2. It is the contention of learned counsel for the defendant in his final written address that all documents tendered by claimants are all not certified, contrary to the provision of sections 103 to 104 of the Evidence Act 2011. I must say at this stage that learned counsel had objected to the admissibility of the documents tendered by claimant and told the court he reserved his right to address the court in his final written address. At this stage, I consider it pertinent to state the position of the Evidence Act regarding the admissibility of documents. Documents under the Evidence Act may be proved by either primary or secondary evidence. See sections 85 and 86 of the Evidence Act. Claimant in this case tendered exhibits A to A9, and out of which exhibits A, A2, A3, A5, A6, and A7 are all originals of the public documents, while exhibits A1, A4, A8, and A9 on certified photocopies of copies of public documents. It is not the law that certified true copy is the only mode by which a public document can be tendered. The position of the law, rather, is that the only admissible secondary evidence of public document is the certified true copy. See the case of Danjuma and another and Kashere citation provided, Aroma Lara and Aguru citation captured, Araka and Ebue citation provided. Where, however, the original of a public document is available, it is admissible as primary evidence without the need for certification. See the case of Issa and the state citation provider, Nagbadu and Farouk citation captured, Kashim and the state citation provided. To put it differently, when originals of documents are not tendered, then it has to be certified true copies and no other. Exhibits A, A2, A3, A5, and A6 and A7 being originals of the public documents are admissible in law and validly admitted by this court. Exhibit A1, A4, A8, and A9 being uncertified photocopies of public documents are inadmissible in law. They are at this stage expunged from the records of the court of the record of this court. In addressing issue 3, claimant's case is on the non-payment of the remainder of the pension and gratuity of his deceased brother, Sule Onoja. Order 11 of the Civil Procedural Rules of this court 2017 makes copious provisions for the way and manner the entitlement of a deceased employee who died intestate may be claimed. For the sake of clarity and comprehension, I will proceed to reproduce the salient provisions of Order 11 of the rules of this court, and it stipulates thus, I quote, entitlement of deceased employee intestate. Proof of status as kinship. 1. Where a case involves the outstanding salary, gratuity, pensions, benefits, or any other entitlement of a deceased employee who died intestate, but had named the next of kin or beneficiary in the deceased employment validator form. If such next of kin or beneficiary is the claimant or claimants A, shall provide proof of the next of kinship or relationship either by certified true copy of employment form, 1, a certified true copy of the employment validator form in which the claimant was named as next of kin or beneficiary on the form obtained from the employer of the deceased employee, or 2, a copy of the employment validator form of the deceased which may be in custody of the claimant or claimants in which the claimant or claimant has deposed to an affidavit. Letter of administration from probate registry. B, attached letters or letter of administration obtained from appropriate probate registry of the High Court or application for order to produce employment validator form. The claimant may apply to the court for an order compelling the employer of the deceased to produce before the court a copy of the employment validator form of the deceased in which the claimant was named as next of kin or beneficiary. Claimant may use document in claimant's possession. 3, where the employer fails, refuses, or neglects to comply with the order of the court, claimant shall be at liberty to make use of any copy of the same employment validator form in the claimant possession to prove the claim, where there is no next of kin. 4, where a case involves the outstanding salary, gratuity, pensions, benefits, or any other entitlement of a deceased employee who died intestate and did not name a next of kin or beneficiary, the claimant shall, in addition to any other document, A, attach letter or letters of administration obtained from the appropriate probate registry of the High Court, or B, an order for a customary court of appeal or Sharia court of appeal, matters to be placed on fast track. Any process related to or connected with outstanding salary, benefits, allowances, gratuity, pension, or any other entitlement of a deceased person filed in any of the registries of the court shall be placed on fast track, unquote. I've captured above the provisions of the rules of this court as it relates to where a case involves the outstanding salary, gratuity, pensions, benefits, or any other entitlement of a deceased employee who died intestate and named a beneficiary or next of kin, and one who did not name a beneficiary or next of kin. From the fact of this case, there is nothing to show that claimant named a beneficiary or next of kin in his employment validator form. Thus, it is the provision of the rules in order 11, Rule 4 of the rules of this court as to where no named list of kin or beneficiary is given that will apply, and which provides those, I quote, where a case involves the outstanding salary, gratuity, pensions, benefits, or any other entitlement of a deceased employee who died intestate and did not name a nest of kin or beneficiary, the claimant, in addition to any other document, A, attached letter or letters of administration obtained from the appropriate probate registry of the High Court, or B, another from a customary court of appeal or Sharia court of appeal, unquote. The claimant, in compliance with the above provision of the rules, has tendered before this court several documents, including the death certificate of a deceased and the letter of administration issued in his name as the administrator of the estate of his late brother. The defendants in this case, from their joint statement of defense, particularly by paragraph 9 thereof, have clearly admitted the fact averred by claimant in paragraph 11 of the statement of facts that the benefit of deceased Sule Onoja was calculated at 972,291 naira 68 kobo. It is elementary law that facts admitted needs no further proof. See the case of Honorable Usman Ibrahim Ali Usman and others. Citation captured. The case of Barua and others versus Consolidated Tin Mines Limited and others, citation provided. Ehila One Oke and others, citation provided. Akinlagun and Oshoboja, citation provided. However, the first point of dispute between parties is the amount outstanding. According to claimant, only 150,000 naira has been paid out of the total benefit of 972,291 naira 68 kobo, leaving a balance of 822,291 naira 68 kobo. The defendants, on the other hand, are contending that only 662,291 naira 68 kobo is outstanding, as the sum of 350,000 has been paid out of a total sum of 972,291 naira 68 kobo. Claimant viewed his reply to the statement of defense, denied ever receiving any sum apart from the sum of 150,000 naira received, while according to him, was paid in 3 installments, and which the first 3 vouchers of Exhibit B1 lend credence to. He denied receiving the other sum of 200,000 said to be paid in 2 installments of 100,000 naira each by the defendants, which the last 2 vouchers were said to cover. In fact, claimant in his reply alleged fraud as regards the said last 2 vouchers and even gave particulars of the alleged fraud in paragraph 12 thereof. The law is on the firm matter that allegation of fraud in pleadings is an allegation of crime which must be specifically pleaded and established beyond reasonable doubt. In the case of Obitunde and Onyesom Community Bank Limited, citation captured, the apex court per Fabi EGSC, now retired, said, I quote, fraud must be pleaded with particulars supplied and evidence must be laid on same. Apart from the above, since fraud is a crime, it must be proved beyond reasonable doubt, unquote. See also the case of Telec Drugs Company Limited on an Ankpa, citation captured, Orga and Ikpeazu, citation provided, Agi and PDP and others, citation provided. In the case of Intux and MPA, citation provided, where Muhammad JSC succinctly explained fraud, thus I quote, it is said that fraud is an intentional perversion of truth for the purpose of inducing another, in reliance upon it, to part with some valuable thing to him or to surrender a legal right. It is a false representation of a matter of fact, whether by word or by conduct, by false or misleading allegation, or by concealment of that which should have been disclosed, which deceives and is intended to deceive another, so that he shall act upon it to his legal injury. Fraud is a cankerworm and indeed insidious disease. It is a strong vitiating factor, unquote. See also the case of Idigbe and FRN, citation captured. It is thus clear that fraud has to do with dishonesty. As reasoned supra, claimant gave particulars of the alleged fraud at paragraph 12 of a reply to statement of defense. The particulars include that the last 2 vouchers are irregular with the other vouchers of the 3 installments, in that the 3 installments payments were made with due tax deductions, but the last two vouchers bear no particulars of tax deductions. The first three installments were properly signed for as received by claimant with dates, but the last two vouchers of 100,000 naira each were not signed, received by Onoja Alaji, fraudulently inserted on one without dates of receipt, while the second one is blank. In essence, claimant is denying the last payment of 200,000 naira in two installments of 100,000 naira each. Claimant under cross-examination, while as if monies has been paid to him as death benefits and gratuity, maintained that only 150,000 naira has been paid, leaving a balance of 822,291 naira 68 kobo. In fact, he answered in the affirmative when he was asked that 50,000 naira was paid to him on the 9th of October 2007, and equally stated categorically that the payments were made in checks and through vouchers signed to acknowledge receipt. The said vouchers are before this court as Exhibit B1, and I've perused them, and I find that though DW stated under cross-examination that the first three vouchers have no signature of claimant as pleaded in paragraph 12 of the reply to statement of defense, the first three vouchers covering the sum of 150,000 naira in three installments, which claimant admitted to be the only sums received, have at the bottom right-hand side of each the signature of claimant together with the date of receipt in the first two. I must at this stage say that this court has the unbridled license under the provision of section 101 subsections 1 and 2 of the Evidence Act 2011 to engage in adjudicative exercise of comparison of signatures. See the case of Aye Junior and Company Nigeria Limited and another, and Akin Jagunla and another citation captured, Akman and Obot and another citation provided, Udutola and Mabugunje, citation provided, Ndoma Egba and ACB PLC, citation captured. In fact, the court, in exercising its adjudicatory powers under section 101 of the Evidence Act, compare the claimant's signatures on the first three vouchers in Exhibit B1 to his signatures on the processes in the file before the court, and found them to be regular and mirrored his signatures on the three vouchers. However, the last two vouchers, which are disputed, do not have such signatures of claimant, in the sense that the one dated May 2012, just the name Onoja Alaji on the bottom right-hand side of it, has just the name of Onoja Alaji on the bottom right-hand side of it. There is no signature on it. While the one dated November 2012 has no name of the claimant, not to talk of signature. It is equally noticed that unlike the first three vouchers, the last two vouchers, which is disputed, has nothing to show that there were tax deductions on the said alleged payments. Besides, the position of the law is clear that the burden of proof of a particular fact is on the party asserting the positive, the affirmative or positive, not on the party affirming the negative. So the case of Oji and Doji Telstar Mills Nigeria Limited, citation captured in Wavu and Okoye, citation provided. This is because in law, it is he who alleges positive that carries the burden of proof of what he has positively alleged. There's really no initial burden on he who alleges the negative, since the negative is ordinarily incapable of proof. So the case of Osokoya and Onigemo, citation provided. Claimant is asserting the negative that he was not paid the subsequent 200,000 naira in two installments as covered by the last two vouchers, and alleging that the last two vouchers are a product of in-house fraud in the defendants, which particulars of fraud he gave, and which court analyzed above. The defendants are asserting the positive that he was paid. Then the burden is on the defendants to prove that claimant was actually paid by dislodging claimant's allegation of fraud on the last two vouchers. Then the defense counsel also failed to cross-examine claimant as to his assertion, denying that the last two vouchers are products of fraud. It has been held in plethora of case law authorities that the effect of failure to cross-examine a witness upon a particular matter is a tacit acceptance of the truth of the evidence of that witness. See the case of Andrawuz and another versus Masha, citation captured, Taiwo and Adegboro, citation provided. The failure of the defendants to cross-examine claimant as reason above is a tacit acceptance of claimant testimony in his additional written statement on oath, denying the receipt of the sum of 100,000 naira each covered by the last two vouchers in SBB1 and the allegation of fraud raised as per the last two vouchers. I'm mindful of the provisions of the Evidence Act as to the presumption of regularity in favor of the official acts or conduct by public officers. This is often expressed in the Latin maxim omnia presumptor right esse acta, which means that all acts are presumed to have been done rightly and regularly until the contrary is proved. See the case of Tory and National Park Services of Nigeria citation provided. Excuse me. However, it should be noted that every presumption, including presumption of regularity of official conduct, under Section 168(1) of the Evidence Act is reportable. This is because for the presumption to be applicable, the act done must have been done in a manner substantially regular. Thus, where an official act is shown on the face of it to have been done in an irregular manner, the presumption will not operate in its favor. In the instant case, the fact that none of the last two vouchers that make up SBB1 has signatures of claimant as seen in the first three vouchers, and the fact that the last two vouchers bear no particulars of tax deductions, unlike the other three vouchers, effectively removes the transaction covered by these two last vouchers, carrying the sum of 100,000 naira each from presumption of regularity. See the case of Adama and others and versus Kogi State House of Assembly and others citation captured. Thus, the facts listed above and in respect of which claimant alleged fraud as shown on the face of the last two vouchers are enough to rebut the above presumption, and thus the presumption cannot operate in favor of the last two vouchers. It is in the light of the above that this court discountenances the last two vouchers and accept the claimant's testimony that only 150,000 naira has been paid out of the whole death benefits, as he never received the sum of 200,000 naira alleged to have been paid in two installments of 100,000 naira each. Now, the second point of contention between parties as regards the non-payment of remainder of the death benefits. The excuse of the defendants that there is paucity of funds, and also that they have not said they will not pay the balance of death benefits, in addition to their contention that they never promised to pay out the remainder of death benefits of the deceased out of bailout funds is preposterous. It is very disappointing, to say the least, that death benefits of a public servant who died in active service as far back as 2004 is still yet unpaid, almost 2 decades after the claimant even had to bring this action in the first place. The defendants started paying the money in bits and piecemeal of 50,000 naira, as if it is some sort of money for groceries, which at this current economic realities cannot so buy. For almost 2 decades, the defendant found it very hard to pay the death benefit, which is made up of gratuity and death pension of a deceased public servant, which sum is less than 1 million naira, having actively served the government unto death. All courts of law and equity are the keepers of the conscience of the society and prevent any person or authority from acting against the dictates of conscience. It does not lie in the mouth of the defendants to say that they have not said they will not pay. If they intended to pay at all, it will not take them this long to do so, knowing fully well that the death benefit is made up of pension and gratuity of the deceased. Perhaps unknown to them, the Constitution expressly forbids any such withholding of pension or gratuity of a public servant by an employee or authority as provided in Section 2101 and 2 of the Constitution. It is appalling and unacceptable that political office holders will hold office for 4 years and are paid huge sums of money, which fact is so notorious and not reasonably open to question. But the death benefit of a career public servant who died in active service will be withheld from his beneficiaries almost 2 decades after his death. The defendants have failed woefully in their administrative duties when they failed to pay the remainder of the death benefits of the deceased Sule Onoja in the sum of 822,000 naira 822,291 naira 68 kobo. And the law and equity leans against such reckless, disheartening, and arbitrary act of the defendants. Howbeit, there is no doubt that the defendant failed in their administrative duties to pay the death benefits of the deceased Sule Onaja to his children, but whether such failure constitutes a breach of the fundamental rights of the deceased children in sections 33, 34, 43, 44, 1 and 2 of the Constitution and Articles 2, 3, 4, 5, 7, 8, 9, 10, 11, 15, and 17 of the African Charter on Human and People's Rights Ratification and Enforcement Act is another ballgame. This right referred to our rights to life, dignity of human person, right to acquire and own movable property, immovable property, and right against compulsory acquisition of movable property or interest in immovable property. It is the duty of the claimant who is alleging the breach of these fundamental rights to lead positive evidence in support of same. It must be pointed out that the rights sought to be protected are those of the children of the deceased, not the claimant himself. Let me say here that Section 43 deals with right to own immovable property, that is real property, and the sum unpaid cannot constitute immovable property or real property for claimants to be alleging a breach of rights of the deceased children under Section 43 of the Constitution. Besides, the claimant in this case has not even pleaded or led evidence as to the details of the children whose right he seeks to protect. In fact, when claimant was asked under cross-examination what the age of one of the said children is, he answered that he does not know. Claimant merely averred in paragraph 23 of the statement of facts that the deceased left behind 5 children, namely Ladi, Chogu, Ladi, Stephen, and Peace Sule Onaja, who also have health issues that requires intermittent medical checkup and spontaneous laboratory analysis that requires the use of finances. No evidence of these claims have been put before the court for the court to exercise its discretion in favor of the claimant that the rights of these named children have been breached. This court is a court of law and facts that must not be set to motion by sentiments, emotions, or crafting speculations and conjecture just to attract judicial interventions. There must be proper basis and cogent reasons for judicial intervention. The court is not a firefighter who swings into action on mere alarm. Claimant has failed to justify his claim for the breach of the fundamental rights of the deceased Sule Onaja's children by the non-payment of a said sum. More so, the court in the case of Komalafe and IG and all the citation captured has held that failure to perform an administrative duty would not amount to infringement of fundamental rights. The court held thus, I quote, "I am of the view that failure to carry out an administrative duty or to administratively address the complaint of a person is not a breach of a fundamental right as contained in the Constitution and other municipal and international legislation on human rights protection," unquote. In view of the above, the court is not inclined to exercise its discretion under Section 254C1D of the Constitution to apply any of the provisions of Chapter 4 of the Constitution on infringement of any of the above rights to the case at hand. The above is not, however, to say that the defendant acted lawfully or illegally by the non-payment of the remainder of the death benefits of the deceased. The defendants, notwithstanding, acted recklessly, wickedly, and arbitrarily by withholding the remainder of the death benefit of the deceased from his estate, which is represented by claimant as the sole administrator. It is in the light of the above that I find that reliefs A, B, C, and D succeed to the extent that the defendants acted unlawfully, wickedly, arbitrarily by withholding the remainder of the death benefit of the deceased Sule Onaja from his estate without lawful justification, and as such should release forthwith the remaining sum of 822,291 naira 68 kobo to the estate of the deceased as represented by the claimant as the sole administrator for the benefit of the beneficiaries of the estate, while reliefs E, F, G, and H fail in their entirety. Relief I is asking for cause of action and 10% post-judgment interest. The law is firmly settled that costs, including cause of action, are the discretion of the court. Judicial authorities have restated the principle The successful party is entitled to cause him unless he has misconducted himself, or there are special reasons why he or she should be deprived of his or her entitlements. See the case of Ezenaka and COP citation captured, Kappa and Alberto Nigeria PLC and NDIC citation provided, First Bank and Oronsanye citation provided. It is also settled that cause of action is not special damages that needs to be proved before it is granted, and it may be granted by the court once its rules empowers it so to do. So the case of Mekuya and Emirates Airlines citation provided. I'm also fortified in my humble view by the provisions of the rules of this court, particularly Order 55, Rules 1, 2, 3, 4, and 5, which empowers this court to grant cause of action at its own discretion. Claimant in this action has succeeded in part in this action and has been able to show that the defendants acted arbitrarily and unlawfully by failing to pay the remainder of the debt benefits of his late brother, whose estate he is the sole administrator. If the defendants had paid the debt benefits of the claimant on time, there would not have been any need to file this suit, incurring costs and time expended on same. It is in view of this that I exercise my discretion in favor of the claimant and awards the sum of 1 million naira as cost of action. It is tried that post-judgment interest may be awarded even where it was not pleaded because it is statutory and it is at the discretion of the court. See the case of Femisia and EcoBank citation provided. However, the rules of court regulates the discretion of the court by setting the rate or percentage at which such post-judgment interest may be awarded. In the case of Bolanli and Access Bank, citation provided, the Court of Appeal held that the power of the court to grant post-judgment interest is statutory as it derives its root from the rules of court, and that this court, as a trial court in that case, derives such power from the National Industrial Court rules. By the provisions of Order 47, Rule 7 of the rules of this court is empowered to grant post-judgment interest at a rate not less than 10% per annum. Claimant in this case has sought and gotten monetary claims, and as such can ask for post-judgment interest, which can only be granted where there is monetary claim. I therefore exercise my discretion in favor of the claimant by awarding post-judgment interest at the rate of 10% on the judgment sum. Accordingly, this judgment is to be complied with within 14 days, failing which it will attract 10% post-judgment interest. For the avoidance of doubt and reasons earlier given, I declare an order as follows. 1. Now the defendants acted arbitrarily by withholding without justification the remainder of debt benefits of the deceased Sule Onoja, who died since 2004, from his estate from the benefits of the beneficiaries of the estate. 2, that the defendants should pay forthwith the sum of 822,921.68 kobo, being the remainder of the debt benefits of the deceased Sule Onoja, unlawfully arbitrarily withheld from his estate since his death in the year 2004. 3, the defendants are liable to pay the sum of 1 million naira as cost of prosecuting this action. And 4, this judgment is to be complied with within 14 days, failing which it shall attract 10% simple interest. Judgment is accordingly entered.
My Lord, respectfully, with all my Lord, and the case for the defendants.
What's your name?
My name is Oyetujokai, my Lord. Acting Director of Justice, Kogi State, for the defendants. We thank your Lordship for the judgment just delivered, for patience and the pain your Lordship has taken to deliver the judgment. I'm most grateful.
My Lord, on the part of the claimant, we are grateful to the court and thank you so much for this continuous legal education. God bless the court. Thank you. The court. Thank you.
Thank you. So the court will send a copy to Lakoja Clean copy to Lakoja. Very well, I'll rise.